begin? Great.
All right, we're going to begin. Hi, I'm Elizabeth Hudson. I'm the Dean of the College of Arts, Media, and Design here at Northeastern. It's a great pleasure to welcome you here today, and I want to thank Amanda Lawrence in particular for organizing this panel as a way to conceive of using an interdisciplinary approach to delve into one of the abiding issues for the disciplines that come together in the College of Arts, Media, and Design, and that is the notion of creativity itself. Like Northeastern as a whole, the College of Arts, Media, and Design is working to push interdisciplinarity to a new level by emphasizing how the disciplines across CAMD provide deeper insights across a wide spectrum of fields in foundational literacies such as creativity, communication, and collaboration. And in turn, by exploring the ways in which the forms of knowledge that are formulated across many branches of learning can inform and enhance our perspectives within our disciplines. Like so much of this kind of interdisciplinary work, the results are sometimes surprising, even deeply disruptive, and cause us to rethink our fundamental assumptions about what we do and what we think we know. This panel is a case in point. Creativity is one of the driving values of our age. It's understood as core to the future, whether we're talking about the future of learning, the future of work, or any other future that we tend to focus on these days. Within the arts, creativity is both highly valued and even exalted, and yet oddly taken for granted and under-articulated. We understand it's vital, but we have not developed very robust methodologies for defining it. Some of our fundamental values for assessment and critique have thus tended to take a peculiar attitude towards the creative, namely, taking for granted that originality is the ultimate value without acknowledging that creativity and originality are not at all the same thing. I love the way in which this panel is taking what might seem to be a fairly mundane and workaday issue, copyright and artists' legal rights, to cut to the very heart of this complex issue of how to separate creativity from the notion of originality. As Lisa Feldman Barrett has articulated in her new book on the secret life of the brain, our brains can only process sensory perceptions by linking them to something we have perceived before. Without that link, we have become what Lisa refers to as experientially blind. We don't know how to process what is before us. As she has demonstrated, we literally cannot see a particular representation without having already built a conceptual framework for it. As the premise of this panel has laid out, however, to question the notion of originality challenges the very myths of genius and invention to which we seem to want to cling. By accepting that challenge, though, we can explore a richer understanding of how all creative art acts rely upon, but also rework the past. Thus, the critical questions on this panel, while centered on architecture, raise fundamental issues to all creative fields. How do we create the new from the old? How do we protect the creations of artists and architects while being mindful of overly prescribing or restricting creative freedoms through legal measures? I'm sure this panel will inspire you to think more broadly about the arts, about originality, and about creativity itself, and demonstrate the way in which we need lawyers to understand these complexities, just as the precision of the law can challenge us to articulate new perspectives on these critical issues. Thanks so much. Thanks, Amanda.
Thank you. Thank you, Dean Hudson, for that introduction. Thank you also to Jessica Silby and Susan Montgomery and today's organizers for this event and for allowing me to participate in it. I'm delighted to be here today moderating this panel on architecture and copyright, to be representing the College of Arts, Media, and Design, as well as the School of Architecture. And I am particularly excited to be flexing our interdisciplinary muscles a bit. It's thrilling and a bit daunting to be among these strange fellows, bedfellows, aka lawyers, and an affirmation really of the kind of debate and discourse that I know we all cherish here at Northeastern and also in the university setting more generally. For today's panel, I've organized an incredible group of panelists with expertise in architectural history and criticism, the law, legal history, and I should say in almost every case, combinations and permutations thereof. And I've asked them to speak about architectural copying. Now, within the field of architecture, copying is, of course, taboo. No architect would admit to plagiarizing another. And as Dean Hudson alluded to, originality and innovation are foundational concepts in the discipline, as in all artistic fields. But copying in various guises is also ubiquitous within architecture. In fact, copying lies at the very heart of the discipline, which since its very inception has relied on the borrowing and reuse of elements from the past. From the Italian Renaissance of the 15th century to the neoclassicism of the 18th century through postmodernism of the 1970s and 80s, imitation of past architectural styles and even specific architectural examples defines architectural history. The first architectural theorist, Vitruvius, wrote that men are by their nature imitative, and that architecture itself imitates not only nature but also other architectural examples. The great Renaissance architectural theorist Leon Battista Alberti wrote that if an architect admired something from the past, by all means he should adopt and copy it. More recently, and closer to home, Italian architect Renzo Piano was interviewed in the Boston Globe about his glass and steel addition to the Isabella Stewart Gardner Museum here in Boston, and he said, "Architecture is an art that takes from everything. It's really robbery, but robbery without a mask. You don't really care where ideas come from. You pick and take from yourself and others." But when does that act of robbery that Piano alludes to, that is so embedded, even expected within the discipline, become an actual architectural crime? That question has become more pointed and more complicated since the passage in 1990 of the Architectural Works Copyright Protection Act, the AWCPA, which states that buildings, not simply drawings, are now subject to copyright protections. More precisely, that quote, creative architectural works, end quote, and that's the language that it uses, are copyrightable, and I'm sure we'll talk about that language a little bit more. I just want to so I'd like to introduce a few general questions that I hope will underlie and guide our conversation today, and then I'll go ahead and introduce the four panelists. So the first one is, what is an architectural copy? This may seem a simple idea, but in fact, the specific contours of its definition are difficult to ascertain, and moreover, and this is particularly relevant to today's panel, how we define a copy in architecture and how the legal profession defines a copy in architecture might not be the same thing, or at least there seem to me to be mismatches and misalignments of disciplinary terms and fundamental principles. A corollary to that question is, how has the architecture copy been defined historically? I just alluded to some earlier theorists, and we'll consider examples in which the copy was construed largely as a positive notion, right? In particular, the figure, perhaps the greatest architectural genius in history, Michelangelo, we'll talk about how he viewed copying as a necessary and positive part of architecture practice. We'll look at the ways also in which discussion of architectural copying historically within architecture in the Renaissance, and particularly, was actually intimately tied to the law. So what is a copy? How do we define it historically? And then another related question is that what words, what terminology, what vocabulary do we use? And this is something that I think that strikes me when I look at these two discourses together, is, who deploys the vocabulary? What is the vocabulary? Many of the terms used to define and think about copies in the law, terms like substantial similarity, the separability paradox, these mean nothing to architects, while others, like originality, mean a lot to architects and are foundational and yet difficult to define both in architecture and legal terms. We'll hear today about what that has meant for the entanglements of lawyers and architects in copyright cases both before and after the passing of the 1990 law. And I'm particularly excited about this because although it's now been in effect for over 25 years, there's been little scholarly consideration of the AWCPA in architecture, and certainly none that I know that's really brought together the expertise of architectural and legal scholars. So this leads to another question, and these are all, you can see, kind of interrelated, which is, what is an original architectural creation? Unlike sculpture or painting or other arts, architecture always also has a utilitarian purpose. This is what, as my understanding, has kept architecture from being copyrighted before 1990, right? So previous to that, architectural drawings and sketches and models were copyrightable as artistic creations. But in architecture, it was seen as too difficult to separate out the useful from the non-useful. I was struck, by the way, in Phoebe's presentation when she was talking about the 3D printing of ears and noses, and the idea that those are both aesthetic articles, right? But so that, in other words, that you could copyright those potentially, but as soon as they're useful, then we're into the realm of patent and they're no longer copyrightable. Architecture maybe shares something with prosthetic ears. So what parts of architecture are creative and what parts are useful? If all architectural creations rely on knowledge of past precedents and to a greater or lesser degree reference them, is there any architectural creation that is purely original? From an architectural standpoint, this is an unanswerable question, or perhaps one that relies on your ideological position with the field, or maybe the century within which you were born. But in the eyes of the law, the answer is requisite. Which brings me to the final question, which is really a two-part question. So is copyright in architecture benefiting the public and or the architecture profession? And the second part, could we conceive of it differently to better serve either or both of those groups? I'm particularly interested in hearing our panelists talk about this, and perhaps we can focus on this in the discussion. Could there be a kind of commons in architecture, has been suggested by Lawrence Lessig in other fields? What are the fair use aspects of architecture? What would a copyleft architecture look like, and who would it benefit? Just a note about this panel and where it comes from. This emerges out of my sabbatical year, which I have spent in the law school thinking about issues around architecture and copyright, and I would like to thank the School of Law, the College of Arts, Media, and Design, as well as the Provost Office for sponsoring this work. I look forward to hearing from the panelists and hopefully the audience as well around these issues. So I now would like to introduce you to the four panelists in order of their presentation. They don't actually know this yet, but they're arranged in order of their presentation. So our first panelist is Jay Wickersham. Jay is an architect and lawyer. He's a founding partner of the Cambridge firm here in Massachusetts, Noble, Wickersham, and Hart, and they represent over 200 architecture and design firms around the U.S. and worldwide. Jay's worked in all aspects of design, planning, development as both a private lawyer, a government regulator, an architect, an urban planner. Between 1998 and 2002, he served as the Assistant Secretary of Environmental Affairs for Massachusetts. And as the state's Director of Environmental Impact Review Program, he oversaw the review of projects including the Central Artery, the expansion of Logan Airport, and Cape Wind. So he's a registered architect with 10 years of professional experience. Also, I think relevant for our purpose today, for over 15 years, he's been teaching architecture practice and ethics at Harvard's Graduate School of Design, which means he's taught almost half a generation of architects about copyright and contracts. So he's also the incoming president of the Boston Society of Architects. And last but not least, he's writing a book on Charles Bulfinch. If you don't know, that is the architect of the State House here in Boston. Interesting that embedding architecture and law in a structure. I also just, his talk today will address some of the more hands-on experience negotiating contract. He told me that it could be titled, "Be Careful What You Ask For." So Kevin Collins is a professor of law and director of the Intellectual Property and Technology Law program at the Washington University School of Law in St. Louis. It was through Jessica Silby that I first became aware of Kevin's scholarship, so I want to thank her for that introduction. Kevin has knowledge and experience in the fields of architecture and law. He holds a JD from Stanford, clerkships with Judge Sotomayor on the Second Circuit Court of Appeals, and Judge Clevenger on the U.S. Court of Appeals for the Federal Circuit, and he writes regularly on patent protection for software and biotechnology inventions. Before becoming a legal academic, he had earned a master's degree from Columbia and worked as a project architect with Bernard Schumi Architects in New York and Paris, who, I don't know what the equivalent, that would be like clerking for the Supreme Court, I guess, right? So that's one of the best-known architects in New York. Schumi was dean at Columbia University for many years in their architecture program. He also has an undergraduate degree from Yale in molecular biophysics and biochemistry, and I'm not sure how we're going to work that in, but maybe we can get that in the conversation, maybe related to the last panel. And finally, Kevin is the author of a forthcoming book on the intellectual property of architecture, so I know he's steeped in this topic at the moment. Maybe he'll have the hardest time condensing his down to 10 minutes, which is what I've asked each of the panelists to speak for. Next to Kevin is Cammy Brothers. She's an associate professor here at the School of, in College of Arts, Media, and Design. She has a joint appointment in architecture and art and design. She previously taught at the University of Virginia, where she held the Val Marana Chair and was founder and director of the Venice program. Cammy has just joined us this year at Northeastern. We're delighted to have her as part of the faculty. So she's an art and architectural historian of the Italian Renaissance. She's the author of the prize-winning book, Michelangelo, Drawing and the Invention of Architecture. So now you've guessed which of the panelists is going to be talking about Michelangelo. She's currently completing a book on Julianna Dustin and the ruins of Rome, and her other publications consider topics of theories of imitation and Renaissance literary and artistic culture, and architectural culture, Mediterranean artistic exchange, architectural representations, and I'm really looking forward to hearing Cammy's more historical view on some of these issues. And finally, Anna Miljački is an associate professor of architecture at MIT, where she teaches courses on history, theory, and design. She would call herself a critic as much as a historian, and in 2014, she was curator of the U.S. Pavilion for the Architecture Biennale in Venice. Anna holds a PhD in the history and theory of architecture from Harvard and a Master of Architecture from Rice. And her work focuses really on the intersection of politics and products and circumstances of architectural labor. So she looks at subjects ranging from Cold War era Eastern Europe through theories of postmodernism and late socialism to politics of contemporary architecture production. She's the author of The Optimum Imperative, Czech Architecture for the Socialist Lifestyle, 1938 to 68, which I'm delighted to say was just published by Routledge a few months ago. And Anna and I are also working on a book of collected essays together called Terms of Appropriation to be published by Routledge this year. So we've been thinking and talking a lot about this subject for some time. So with that, I'd like to invite Jay to start off the conversation. Thank you.
Okay, well, thank you very much, Amanda. And how is this? Does the mic work well? Okay, great. Okay, well, since I have only 10 minutes, I'm not going to delve into any of the complex theoretical issues. I'll let my other panelists delve into that. I do share, and I'll look forward to a conversation, a lot of doubts about the impact of copyright law upon the culture of architecture. But I'll talk about it from a very specific perspective, which is as a lawyer for architects negotiating contracts. And because this is actually how it plays out. Anyone here who's worked in the environmental field knows if you've worked out west, there's a saying, water flows uphill towards money. And I would generalize that to say that in any form of legal entitlements, once we establish an entitlement, that entitlement will run uphill towards money. And so, a little more broadly, once we create an entitlement in architectural design through copyright, it is going to be the party with the greater power and the greater bargaining power and leverage who winds up with those rights, and that party is never going to be the architect, not in any project of any significant scale. So I have kind of a lot of firsthand experience day in and day out negotiating for some very eminent architects, with very differing views on creativity. Our firm's clients range from Diller, Scofidio, and Renfro, who designed the ICA here in Boston and the High Line, to Robert A.M. Stern architects, architect of the Spengler Business Center at Harvard Business School, whose firm is completing 2 new residential colleges at Yale that are fully Gothic revival, including stone tracery and gargoyles. So we have a wide range of attitudes towards copying, history, originality. But all of these clients are dealing with the same situations when it comes to who controls the copyright in the documents. And by the way, that actually is something I will say, in, 25 years of this, there hasn't been more than a handful of times when there has actually been a client who had the sophistication to understand that there was a copyright in the building that my architects were going to design for them, and maybe they might want to get control of that copyright in the building. That passes them over entirely. So that my clients always get to keep the copyright in the building, but that actually is not has no value to them. What they care about is who controls the drawings through which the building is documented. And by the way, these drawings are not exciting documents. These drawings will be several hundred drawings with excruciatingly detailed renditions of exactly where every single one of those lights and diffusers and sprinkler heads is located, and how the different systems are oriented relative to the invisible steel framing up above, and where the fireproofing all goes. That is what is in these documents that my clients and the architects and the clients are fighting over, is control of that degree of specificity. So just kind of, to give a little bit of the the two viewpoints then, the American Institute of Architects publishes standard form contracts. And for many years, the American Institute of Architects has, wanted to make it very clear that architects, copyright in the architect's drawings is something of value, and the architect should keep it. And so if you look at those form contracts, the words are quite revealing. The architect's drawings in an AIA contract are called the instruments of service. And so the implication here is that this is a professional who is providing a kind of a customized professional service, and the drawings, therefore, are really kind of instruments of that larger body of service that is being provided. If you went to a doctor and you pay the doctor's instruments of services are things like the stethoscope and the forceps, and you wouldn't expect to take those home with you after you had an appointment. And so I think something of that implication was probably behind this coining of the phrase instruments of service. This is something that should adhere to the architect. It's specific and unique to this project. It's really not something that's appropriate for the client to have. However, any client of sophistication these days has their own form of contract. They don't accept the AIA form. And typically in that, the architect's drawings are called the work products. And so again, this is a very, I think a very clear coining. They are products. They are something that is fungible, something that is transactional, something that perhaps could be reused on future events. Even the word work products perhaps wants to have an overtone of the copyright term work for hire, in which whatever an employee creates belongs to the employer. And so it's kind of that viewpoint, because again, when we talk about authorship, clients actually feel a deep sense of authorship in their buildings. They conceived of doing this building, they conceived of the uses, they paid for it, and so there's a very visceral feeling that I paid for this design, I should own it, and so therefore in the contract, I want to make sure that I own the copyright. And by the way, the place where this is most prevalent tends to be in major universities. I would much rather negotiate a contract with the most rapacious real estate developer than with an Ivy League university. Because a real estate developer understands this is a business transaction, and they understand their business needs and the architect's business needs, where universities have a knee-jerk reaction that intellectual property is something of value and we want it. So we want it so we can harvest it. And the fact that the drawings of a university library are utterly valueless, that university will never build another library. They won't sell it to another university because the donor would be very unhappy to see that design replicated on another campus somewhere. So there's actually no real reason why the university needs to own that copyright, and yet there is this knee-jerk reaction, largely from people, I think, untutored in the field. So just to kind of, I'll kind of turn it over, but sort of what are the real issues here are, because architects don't perfectly copy themselves, what architects want is the ability to be able to continue their art, to reuse elements of their design on other projects. And that's what I'm always pushing for. In other words, architect is a process of evolution. And so the ability to take and reuse details, elements, I'm always happy to say in a contract, we will not replicate the design in its entirety, so long as we can reuse those elements, so long as there is the understanding of the continued flow of ideas within the firm's work. And so long as the other thing we want is we want to make sure that if our design is used and we are not involved, we have no risk. Because again, buildings are complicated things. What is in the drawing is only a piece of what actually goes into putting together a building that will stand up, keep the water out, do all those necessary things. So we will always allow our drawings to be reused by the client if they're going to do an addition or a renovation, just so long as we don't bear the risk. That risk now goes to you. And that really is what the client cares about. The client wants to make sure that they can keep reusing these ideas Within the building, they may want to have some family resemblance between this and the building next door on the campus. That, all of that is fine. And there are various ways that you can unbundle the bundle of property rights and come up with a kind of a reasonable delineation between the two. But the kind of the knee-jerk reaction of, I paid for it, I want it, I'm going to own it, versus the architect's kind of knee-jerk reaction, this is great, copyright is something that I created it, I'm going to own it, I don't want to give any of it away. Neither of those are particularly helpful viewpoints, either for the building project itself or, I think as we'll hear from our panelists, for the larger culture of architecture.
Thank you.
I have a couple slides, so I'm going to move over here. Okay. So, as mentioned, I'm writing a book right now on the intellectual property of architecture, so I thank everyone for coming together to have this conversation. One aspect of that book's focusing on copyright law. There are also a number of interesting stories to be told about patents, design patents, and trademarks with respect to architecture, but we'll talk about copyright here today. I was asked to talk a little bit to kind of introduce this recent change in United States copyright law for architecture. In 1990, the Architectural Works Copyright Protection Act. I'm then going to turn around and talk a little bit about what this might mean for architectural practice and share some data that I've been gathering about the way it's actually been used over the last 25 years. So prior to 1990, there was a very unusual, well, I should say in 1990, architects were granted copyrights that roughly resemble the rights that other creative professionals have. They're the copyrights with which we know and maybe love. They are a right to prevent the copying of original expression from a work in a substantially similar manner. However, before 1990, there was a kind of architecture-specific rule about how copyright worked. You have to understand that architectural expression, as mentioned before, can be embodied in two different forms. You can either have a drawing which embodies architectural expression, or you can have a built building. And then, in turn, if you think about how this can be copied, it creates four different possibilities. You can copy a drawing into a drawing into a building, building into a drawing, or a building straight into a building, although that's really not plausible unless it's a lean-to of some kind. Well, what did the pre-AWCPA copyright rule say? It said that it was impermissible to copy protected expression in a substantially similar manner from a drawing into a drawing, but all these other three kinds of copying were fully permitted. There was no execution right for a drawing. That is, if you managed to get your hands on a set of drawings legally, you had a right to build a building, and building a building wasn't considered to be making a copy of the drawing. More importantly, for what we're talking about here today are the two categories over on the right. Once that same expression that was protected in a drawing became available to the public in the form of a building, one could freely copy that protection, that expression which was protected when it was in the drawing, from the building without running afoul of copyright. This is kind of a wild, strange system. Imagine you're a mural artist and you could get protection for the drawings and sketches for creating your mural, but not for the mural itself once it was made available to the public, right? So this was an unusual unusual copyright regime which governed architecture. Here's then the marginal rights, which I think are what we're interested in. What did the AWCPA change? Well, it changed whether an architect can freely copy another architect's original expression without permission from a constructed building and in a substantially similar manner, right? This is what architects could do before the AWCPA without running into copyright issues. It's what they cannot do in theory. We'll talk about in practice whether it's actually different after the AWCPA. So, and here are some of the complicated questions. Should architects really care about this shift in the law? And I'm going to say, in many ways, actually, I'm not sure so far there's that much of a reason for concern, although that might shift in the future. The standard story about copyright, if I'm going to put on my hat that I teach when I stand up, the hat that I wear when I stand up in front of a copyright class, and say, well, the theory behind copyright, of course, is if you give creators more rights, you're going to have an expectation that they can profit from their creativity, and therefore they'll create more and better. I wonder whether that's actually true in the architectural world. I wonder whether we were living in a poverty of creative architecture prior to 1990. But that's one concern we have to think about here. There's also, of course, the cost, which is once you start to tie up creativity within privatized bundles, it becomes more difficult for later generations to borrow from and build on that creativity. There was a concern mentioned earlier by Jay, about architects wanting to keep enough control over their own creativity so that they could continue to build on it. Well, of course, each architect also builds on the creativities that comes from other people, and the question of whether or not the new prohibition on copying protected expression from buildings is going to significantly affect architects' ability to do the kind of borrowing or copying they do in everyday practice is one of these open, complicated questions. And the reason why it's open and complicated is because I'm assuming people who are architects in the audience want to turn to the people who are lawyers and say, so what constitutes a substantially similar copy to protected expression? That's a very long story worth several weeks of lectures in copyright class, where at the end of the day, the goal is to convince your students that actually there isn't certainty and that there's a lot of flux in the law. You can also then ask whether in everyday architectural practice, the kind of copying that we engage in is actually actionable copying. It may well be that the kind of copying that architects enjoy engaging in and find productive is a kind of copying that copyright does not extend to, because copyright doesn't protect all aspects of a building, and it only protects substantially similar copies, and there's this fair use doctrine, although I'm not sure that's actually to date been very important in the architecture field. And then once you ask, well, how does architectural practice generate copies? This, of course, is contingent upon a contemporary notion of architecture. Architectural styles change, understanding of what architectural practice is changes, so what might be correct for one correct balance for one generation of architects might not be the ideal rule for another. So these are the complicated open questions which I think are raised by today's panel. Just let me point out, the AWCPA is an unusual moment in the political economy of copyright, because the way in which we usually think about copyright law expanding is the potential owners of broader rights go to Congress and say, please, please, I want some more. But actually, the AWCPA came about expanding architects' right without the architects ever asking for it. We signed some international treaties for completely other reasons that required stronger protection for architecture. And in fact, the AIA initially lobbied against protection for constructed buildings, although it soon turned around, right? So it's not a hard and fast viewpoint, but it is sufficient to point out that we don't have the usual story of copyright owners asking for more rights and getting them here. It's kind of rights being foisted upon architects without their asking, which goes to these questions about exactly whether architects think that these rights might end up being good for the profession overall. So to wrap up, I just want to share a little bit of data I've been collecting about how the AWCPA has played out in litigation in the courts. So I've been compiling cases in which architectural allegations of copyright infringement have been litigated in the courts. I looked at 52-year windows centered on the enactment of the AWCPA. There have been about 420 cases. And then I went through those to understand how copyright litigation has looked before and after the AWCPA. What effect has AWCPA actually had on copyright infringement litigation? I can only share a couple slides with you from this because that's a long story. Here's a quick slide about quantity, how much litigation has occurred. Well, it's easy to say that the AWCPA enactment correlates with an increase in copyright litigation. However, to make the causal argument that the AWCPA actually caused this 11-fold increase in the later 26 years rather than the earlier 26 years is a very complicated undertaking. There are a lot of other things going on, including some other changes to copyright law, some end to some notice formalities, which made it easier for architects to preserve their rights. Fascinating story actually here. We'll get to the network moment. Yes, we too can talk about the internet as architects. A lot of the cases that I'm reading suggest that the internet is critical in this story, not because people are infringing by posting things online, but because the internet has been a fantastic copyright infringement detection mechanism for architectural copyright owners. How does the developer in Florida who owns architectural copyrights know that the people in Boulder, Colorado have just built a house that looks a lot like the house that they designed in Florida? Because now builders are routinely posting their works to the internet. So again, we're in a very different world now in terms of copyright litigation than we used to be, but I'm not going to say the AWCPA caused all of that shift. In fact, I'm going to argue that the AWCPA may have had very little to do with it. In the world of architecture that I usually think about when we talk about architecture. Architecture, building construction industry today kind of exists in two different modes, two different business models. There's a custom model, very much like the clients that were just discussed, right? The people who, clients come to them with projects, architects create projects for clients for particular sites. This is custom work. But a lot of the construction in the United States, especially in the suburban single-family home mode of the construction industry, is about stock designs. You design once and you build multiple copies. If you divide up this quantity into the number of cases involving stock and custom designs, you see a lot of the explosion in architectural copyright litigation involves stock designs rather than custom designs. There has been an increase in the custom design, but the biggest impact of the AWCPA has been where there is arguably the least creativity in the fields of McMansion building and the suburban single-family home multiplication. So that's a little bit ironic, right? If we think about copyright law as a means of incentivizing creativity, we may actually be having a lot more costly litigation in the exact fields where there wasn't that much creativity going on to begin with. A note on geography. You should really care about copyright law if you live in the Middle District of Florida, because there's this long tail, this copyright litigation that's spread out throughout the United States, and at the very end, bam. So does the AWCPA matter? It matters if you're a single-family home builder in the Middle District of Florida, for sure. One last point I'll make is that I think the AWCPA is playing out differently in custom and stock designs. If you look at the number of cases involving custom architecture under the AWCPA, I can't explain this fully in the time here, but let's say the majority of these cases are transactional based. You were talking about how copyright is really important in terms of contracts, right? Most of the cases we see in the custom architecture world are about contract relationships gone south. Right? I designed something for you, I don't think you paid me right, we fight in suit, and I pull out my copyright as one of the weapons in addition to my contract to help in this dispute. Only a small fraction of them involve stranger copying, which is what we think about in the situation where one architect borrows from another, and I can break that 17% down to say there's only a minuscule fraction of cases involving custom architectural design that involve building copying. So in the custom world, the AWCPA might not have had much of any effect at all. However, in the stock world, it's totally different. We see most cases being stranger cases, and even a bunch of the contract cases could legitimately be building copying cases because they're model homes built all the time before any contract is actually signed, meaning I can go to your developer model home, say, oh, I like that design, but I don't want you to build my home. I'm going to have someone else build that home that's already built for me. There, the AWCPA's prohibition on copying buildings becomes important because you couldn't copy buildings before the AWCPA. So that's just sharing a little bit of how the AWCPA is playing out in practice. I think they're really interesting and serious questions about architecture culture, but in practice, the way in which AWCPA litigation has unfolded, it's been almost all contract-based in the custom world that is where we usually think about architectural design.
Thank you.
All right, thank you. So first I want to thank Amanda for including me. I was flattered and surprised as a Renaissance historian to be included in a conference about the future. I am not talking about the future. I am not talking about the present. I am talking about the deep past, or at least the deep past from the point of view of people interested in the future. So about, take your minds to about 500 years ago. That's where I live, and that's what we're going to be talking about today. So the reason that I think it's potentially relevant for me to be here is because, as Amanda suggested, this notion of copying today has almost an exclusive negative valence. So having had to turn in my grades today, I've been thinking about the issue of copying and plagiarism very interestingly, and it's one of the, or very recently, and that's one of the few offenses in a kind of scholarly academic environment, either from the point of view of a student or a professional, from which it's almost impossible to recover. The accusation of plagiarism for a professor, it's essentially the end of a career. But what's so interesting and ironic to me, as someone who works in the Renaissance, on Renaissance topics, is that it was seen not only in positive terms in the Renaissance, but actually as an essential building block for creative expression. So the absolutely prevalent idea about imitation, and this was an idea expressed by humanists, so in writing about literature, writing about poetry, as well as writing about the arts, is that there was no way to become a professional, to become advanced in whatever it was you did, without imitation. And imitation and copying, I'm going to use these terms somewhat interchangeably. Interestingly, there's a kind of law tie-in for this. So where did Renaissance thinkers get their ideas about imitation? Where they got their ideas about almost everything, which was from ancient Roman writers, and specifically Quintilian. So Quintilian died around 100 AD, and he wrote a book about rhetoric, which was specifically directed to lawyers and to trial room lawyers. So it was about essentially the art of persuasion. And in this treatise, he described ways of learning good rhetoric, and that was to do with ways of copying. So the debate in the Renaissance was not about whether to copy or not, it was about how to copy. So a specific debate, and we're talking raging controversy, was about whether you imitated one source, so one excellent source like Cicero, or you imitated multiple sources. And the debate got mean. The people, or one of the principal people talking about this was Poliziano, and he said, oh, if you imitate only one source, you're like an ape. And Cortese came back to him, these kind of nasty letters back and forth. Cortese said, but no, you're like a bee taking honey from multiple flowers. So this was the nature of the discussion. Now, of course, as Amanda said, I'm an art historian, so I want to talk about some art. Let's start with Michelangelo. I don't think I need to introduce Michelangelo even to this non-art historian audience, but he's useful in this context because, in a sense, he's the shorthand we have for a genius. If we want to say somebody has unending capacity for originality and invention, we turn to him. He was one of the masters, not only at imitation and hiding it. So he'd never said he imitated, but he did it to an extraordinary degree. But also, in this, I wasn't going to talk about this, but I recently gave a paper about it, and just referring to the discussions already this morning of self-citation. So he was constantly reusing his own material. He had a file that was not so big, and he just reused and reused and reused. So that's maybe the if I'm ever invited back, that's what I talk about. To speak, not to leave us with only one Renaissance icon of genius, I wanted to just very briefly, I'll mainly talk about Michelangelo, but I couldn't resist including a note about Leonardo da Vinci. So again, this is, all manner of corporations use this image of Leonardo da Vinci's Vitruvian Man as a way of also saying, Renaissance man, genius, etc. You may be surprised to know that in all likelihood, and this is not really a consensus idea, but I would argue it to my deathbed, that in all likelihood, Leonardo cribbed this image from a lesser-known architect named Francesco di Giorgio Martini. Remember that name. It will right the historic wrong that Leonardo gets credit for this image. Francesco's is a little... image is a little bit dimmer. He has a more relaxed version of Vitruvian Man, as you'll note, but the concept is there. Back to Michelangelo. So I want to just briefly mention a few of the reasons for uses and reasons artistically for imitation in the Renaissance. So primarily for Renaissance artists, it was a learning tool. It's how they learned to do anything, how they got ideas, how they, in the era before art schools, it's how they, their form of autodidacticism. So this is one early example, and interesting because Michelangelo was only 11 or 12 years old when he did this. So this is a copy that he made after Martin Schongauer, a very small little northern print. This is a tribute. Michelangelo definitely copied this image. Whether this painting is the one that he made or not is controversial, but that's another matter. He also made extensive copies from paintings of a generation before. So it's significant as well that he wasn't copying his immediate contemporaries. He was copying paintings that were substantially out of fashion. And you could think about why he did this, potentially because they were less detectable. So he made this drawing. No one was going to see this drawing except for obsessive art historians generations later. And he did it. He never inserted that precise figure in his paintings, but he learned about massing, about drapery from Masaccio, who'd been a master of it. He learns a lot from the same set of paintings, the same set of fresco cycles. So this is his copy of Adam and Eve. This is a good illustration of how the copy is never slavish. So it's not a precise copy. Michelangelo's Adam and Eve are characteristically, for him, a bit beefier than Masaccio's. He's always interested in musculature, and so he adds something to his copy. He enhances it. He also copied from the deeply out of fashion painter Giotto, who was painting in 1320. So he went back in, we think about the Renaissance as always forward-looking. We're interested in the future, they were interested in the future. But Michelangelo is copying from a painter 100 years ago. Again, basically undetectable for his contemporaries because no one else was all that interested in Giotto. Now, where does this process, what else does he do with copying? A little bit later in his life, it turns from this kind of autodidacticism to something a little bit sketchier, let's say. So he makes a copy. Now, this is lost, so I'm showing you this as a illustration. He makes a copy of an ancient Roman sleeping Cupid. So this was a typical theme of ancient Roman sculpture. Now, this is not just a case of training himself, and we know this because of the documents surrounding it. So he makes this copy, he buries it in the ground. Why does he do that? Well, it gets the patina, it gets a little dirt on it, it gets the patina of age. Then he stages this elaborate thing where this antiquities collector or antiquities agent uncovers it. That agent takes it to Rome, sells it to who? Some kind of naive person who doesn't know what from what? No, his antiquities agent sells it to the most renowned collector of antiquities in Rome, Raphael Riario, the nephew of the Pope, the person who everybody knows, this man knows his ancient sculpture. This guy buys it. Somehow, it is uncovered that, in fact, this is not an ancient Roman sculpture, but it's by this upstart Michelangelo. Riario is furious, so, gets rid of it immediately. Isabella d'Este, who's a smart woman in Mantua, buys it. But it immensely decreases the reputation of Riario because he's been fooled. It's also very interesting to us that, Riario had no interest in a Michelangelo. But there's a kind of second chapter to this, which is that having acquired this ability to essentially forge an ancient Roman work of art, and so we've moved from copying to forgery, Michelangelo then becomes so good at this that he can basically make a sculpture that looks as if it's a copy but isn't. And so this is a Bacchus. This is Michelangelo's Bacchus, which in another level of irony is commissioned by the same antiquities collector who'd been fooled by the other one. So in a form of kind of regret or something like that. And then there's this wonderful drawing by Martin van Heemskerk in which he's kind of playing on the idea that Michelangelo's sculpture is basically an antique work itself, because in the sketch he breaks its arm and he puts it in this kind of garden of fragments, making it look, it's basically a visual joke, as if it were an antiquity. Amanda said I was going to talk about architecture. I will. Here it is. So Michelangelo came to architecture very late. He was essentially lazy in his way of learning about architecture, so he didn't do what every other contemporary of his did, which was go to Rome, take a notebook, sit in front of the Colosseum. Never did it. What he did was borrow an acquaintance's notebook, copy the notebook, very badly, I might say, in the sense that if you look so this is actually, let me just show you this first. So this is, he doesn't even copy someone who'd been original himself. So this is Bernardo della Volpaia. Volpaia copies Sangallo, and Michelangelo copies Volpaia. Yeah. So he's copying a copy. And as I say, he doesn't do it very well. All the things that are important from a Renaissance perspective are the fact that it's drawn with a compass and straight edge, the fact that it has measurements, the fact that it's identifying where it is. Michelangelo takes a piece of red chalk and is like, done, next page. So he does it incredibly quickly without any of the details. Somehow it seems to work. He gets the knowledge he needs, and he starts to get architectural commissions. And here I just want to turn briefly to another topic, which is that another kind of area that's hard for us to understand, which is that copying also happened because the patrons asked for it. So one of Michelangelo's early projects was for what's called the new sacristy. That's the slide that's closer to me. And it was commissioned by the Medici family as a copy of the old sacristy, which is by Brunelleschi, a generation earlier, part of the same church. So it wasn't like, we'll build it in some obscure place, no one will ever guess that it's a copy. It was supposed to be a copy. Now, depending on your point of view, it's not an exact copy, but it has the same kind of Pietra Serena columns, the plan is the same. It's similar in many regards, and the idea is that this kind of similarity is actually desirable and prestigious and creating a connection to the past. Michelangelo was certainly not the only architect to copy or be copied, and I just wanted to briefly mention, this is material that I'm working on now, that certain kinds of drawings were very attractive to architects to copy, and that was partly because they had a kind of storehouse of material, so like the kind of architectural Wikipedia of the day. So you could go to one source. And so this was Giuliano da Sangallo, who was fantastic student of ancient Roman architecture. He brought together, he'd been, this looks like one compressed page, but this had taken him probably years to assemble this page by going all over Italy drawing these particular plans. So it's kind of magnetic appeal to his contemporaries. Now, some of these, interestingly, these copies, because they're drawn and they're not printed, have gone pretty much undetected. Basically, the knowledge just gets diffused in the culture with kind of no attribution. So this is one example at the Uffizi of an anonymous copy. More anonymous copies. This is from another, well, it has a name, it's in a different location, the Codex Escurialensis, but we don't know the author of this. More copies from the same sheet. I'll just go through these quickly. More copies, more copies. And so why are these being done? Because these drawings contain knowledge that is difficult to obtain in other places. We think, and I think it's worth thinking about, because within Renaissance studies, we think about the mode of diffusion of knowledge as print, that it happened through print, and once the printed books and illustrated books and woodcuts were available, then people imitated them. But actually, there's this huge culture of circulation and copying taking place with manuscripts and drawing. Not only are plans and kind of content of the nature that I just showed you copied, but also modes of imitation or modes of representation. So thinking about, well, what was Julianna Dustin's original contribution? In some cases, it was a way of seeing, and so in this case, we see he's devised this way of seeing inside and outside of a building at the same time. It's something that architects still haven't actually mastered, but he does it here. Others are interested, and they copy it. I wanted to end with an example of what the step looks like between copying and invention, because this is really the kind of crucial passage. It's why they all did it. So here we see just an ancient Roman building that Julianna draws, the Temple of Minerva Medica. Everybody copies from him, and you can tell they've copied it from him because they have the same mode of representation, the same bay, single bay and elevation, as well as the plan. Peruzzi also copies it from him, but he does something really fascinating. And so I'm just drawing your attention to the lower half of this plan. So what he does is he takes this ancient Roman plan and he just extends the bay, extends the nave, and basically changes what was a ancient Roman garden structure into the design of a church through a very, very simple operation. Peruzzi was probably a name less well known to you, but of equal kind of originality and inventive power to Leonardo and Michelangelo. And yet, his mode of invention was this very, very simple operation. So I'll leave it at that, with just that thought that that originality, invention, and copying are completely inextricable from one another in this period that we associate absolutely with originality. So, thank you.
From beginning, yep.
Yeah,
Perfect.
That's
it.
Yeah.
All right, so I want to thank everyone for these great presentations, and Amanda for convening us here today. I am indeed very curious where we might take this in our conversation. So I'm not going to waste too much time, and I'm going to try and stay within our allotted time. But I will definitely present something, or really, as everyone probably in this panel, I was wondering how to address this audience. And I had a version of the talk that was talking about that more custom architect and sort of architect to architect, really Rem Koolhaas's case. But I decided to present perhaps a more popular, as opposed to scholarly, portion of some of my work on the subject of copying. And I am super aware. So when I speak about copyright in the architectural context, I feel like I can control the material enough. Now I'm putting up copyleft, and I'm like, oh my God, who knows how you all are going to read this. But because I come to the question of copying and originality in architecture via architecture and not legal studies, I've been interested in the way that ideas travel author to author across geography and time. And to me, again, with this, in this room, absolutely amateur understanding of copyleft, it seemed like that might be an interesting way that law might help us chart the disciplinary attitudes towards copying more appropriately than WCPA has been able to. And so copyleft, as you know, and again, I'm going to stop saying that I am self-conscious about this, but as you know, copyleft has been a term that is most often found in the, sorry, I'm having trouble seeing my own notes. I am, but it's requiring me to scroll down. So there it is. I found what button works. Sorry, I'm also a Mac person. So. Copyleft is a term most often found in the world of open source software, but it has been applied to other forms of authorship as well. And when used legally in the form of the Creative Commons Attribution Share Alike license, it stipulates that one can do what they want to a source code or a work, so long as they preserve the right for others to do the same. So my understanding of this is that basically if you work with a copyleft work as your source, you have to produce, or rather you have to ensure that the work you produce as a result is equally designated copyleft. So for various reasons, but let's reduce and call them our current technological prowess, the kind of access to high-speed internet, habits of use that we have developed in relation to it, as well as the litigious regulatory mechanisms that have arisen concurrently with those. We are currently culturally sensitized to the idea of plagiarism and copying beyond even the academia, right? Just a few months ago, we all witnessed Melania's alleged cryptomnesia, or her Michelle Obama moment. And on a different end of that equally sort of popular culture register, Pharrell Williams had to pay over $7 million to the Marvin Gaye estate for his blurred lines. And on the occasion of that, he suggested that we needed to protect the rights of authors to have ideas or to be influenced in his case. Now, you probably know this case, but in that case, the court was not deciding about the allegations on replication, but on a claim of similarity due to influence. And this, for everyone who is producing in the realm of aesthetic and cultural production, is a serious problem. Basically, when we're producing cultural products, we are hoping to influence the field. When we are producing in that field, we are in conversation with it because we are being influenced by other things that are produced in it. So these are some of the things that, in a way, float around the material that I'm looking at. And certainly, in the case of architecture, some of these issues, the kind of access to internet, the speed with which we get and disseminate work, have simply meant that we are exposed to more work, thereby also objectively copying more of it. So I'm starting with this excerpt from the research that we did at MIT in our Appropriation, the Work of Architecture in the Age of Copyright class. And it's a kind of timeline that we gave out during our fair use exhibit. And really, I'll spend some time, really the rest of the time, talking about these exhibits that we have developed, that I've developed at MIT with students, and then they've traveled in different forms that discuss or try to look at that intersection of architecture and copyright recently and through history. So fair use, which was the first version of it, its aim was to actually broaden the context and look at really 500 years of architecture and the way in which the profession, the discipline, have at various points in time codified authorship, originality, copying. So for visitors, we gave out this map, which we thought could work visually for everyone to actually somehow locate other moments that we were offering in the exhibit itself. And so what you're seeing here is a line that is dedicated to Le Déjeuner sur l'herbe, the famous one by Monet, but then also Manet, Cézanne, Picasso are around here. Historians have seen some earlier versions as relevant for the most famous painting among these. And then the 20th and the early 21st century have both produced a number of different variations on this project, on this painting. Some of them are in painting, others are in video or performance. Then we also gave everyone, or we
showed basically the way in which some of the technologies that are used for storing and disseminating information have been changing over time. The law, the copyright law, and the way that it has intervened, or rather the moments when it has intervened in the world of aesthetic production, first around here in at the beginning of the 19th century, late 18th, and then in the 18th, with the acceptance of the Berne Convention in 1990, the VAW CPA law. And then the way that architecture appeared here was through a canonical project, Le Corbusier's Villa Savoie, which was built in 1931, exhibited at MoMA, endured damages during the war, entered into the registry of monuments, used by other architects in their work, refurbished, reproduced in China in black, which Le Corbusier Foundation had a real issue with, and I think it was torn down. Lego version of the same, and most recently a project that uses open source models of Villa Savoie to produce a video game. But that's sort of the map in which we were inviting others to locate elements of the exhibit itself. So, as I said, it was developed for fair and later unfair use exhibition, and the exhibition at MIT included a kind of a larger collection of historical elements, while the unfair use later at CCA and Berkeley focused really primarily on the making of VAW CPA. So the exhibit had two parts. One was tongue-in-cheek, and I will bring it up for you because I think it's still fairly important. And the other was full of this kind of historical content. So we included, again, something in a kind of a open-ended timeline, knowing that we probably didn't catch every moment that the discipline articulated its relationship to copying or originality, authorship. But so our point here was that if we look beyond our most recent postmodern chapter that described and talked about a particular way of relating to sources, as we did here, an engagement with the past seems to have been long understood as legitimate and indeed requisite, and you saw that in the Renaissance project, aspect of the creative act in architecture. So, which would lead us to say that appropriation is as much part of the architectural unconscious as the expectation of novelty. In fact, the question of originality, and I know you cannot read these, this is like an excerpt of some of those cards. But the question of originality has been posed at various times in the history of the discipline. Its foundational texts include positioning on these topics. And in this, in fair use, we saw our key task as one of establishing some form of an open-ended timeline or field in which with which we can begin to talk about this in a larger context. We followed questions on the register of theoretical production, which are here in pink, technological developments in various techniques of reproduction, and then law more recently in purple. So the first entry in our timeline is a quote from Vitruvius's 10 books on architecture. Men are by nature given to imitation, and I'm always trying to add women there, but then you know, maybe he was onto something, so I leave it. It's okay. And so these are just some elements that were in our exhibit. So the blueprint machine, which is really, if you are an architect, certainly of a particular age group at this point, you will know how relevant the blueprint machine is or was for the field, or the way in which the question of duplication or copying already occurred in culture around architecture as well. Moments like Roma Interrota, the highlight of, or the peak of postmodernism, when basically architects are literally invited to deal with or take on an old Noli map of Rome, and then many of them end up self-copying, as we already have that term now in the room for this particular project. So the subsequent version of the exhibit, now called Unfair Use, took on as one of its topics the dramatic moment of the drafting of the Architectural Works Copyright Protection Act. And so here, as you probably know, trying to illuminate the boundaries of legal protection for architectural works, Congress invited Michael Graves as an expert witness, who in turn differentiated between internal and poetic languages in architecture, the first being intrinsic to building in its most basic form, determined by pragmatic construction and technical requirements, while the latter, the poetic, which must be conceptually separable from the internal, was described by Graves as, quote from him, responsive to issues external to the building and incorporating three-dimensional expressions of the myths and rituals of society. If the two are fused, the work of architecture is not copyrightable. So this, the important thing about this is that Michael Graves was the only architect witness on the stage. AIA was involved in this process with one representative. But in 1990, this is again kind of a downward curve for postmodernism, which Michael Graves represented, which had particular views of the way meaning travels in the discipline. And it's his particular view that gets, in a way, baked into law at this moment. So in the exhibit, we specifically focused on the characters who found themselves involved in the drafting of the law. And we included interviews with a series of them, and this is Michael Graves' last interview. But we were interested in the fact that basically the law, or that piece of law, is made relatively, with input that is relatively random and based on very personal positions of those involved. And then in the exhibit, you can actually listen to all of these characters and read them, or read the things that we produce. But we also included this, which I called the more tongue-in-cheek portion of the exhibit, which were our fair use moves, we call them, which are all in a way commentary and intervention, both at the same time. We were inspired by the idea that OMA produced actually a body of models for their own defense in a lawsuit. So we thought if we looked at a number of contemporary projects, we could actually categorize them in a series of sort of tropes that are volumetric tropes, which for each one of those, we looked or made sure that we found at least 3 or 4 projects that were within the realm of that form making. So each of our own projects was in conversation with or as a commentary on a number of mostly recent projects. And so in each case, our little formal contribution is both intended to highlight a volumetric trope and to add to the lineage, to call out the theme and give the architects a way out of what we thought was a useless finger-pointing game of who done it first. We also, among these, interspersed the architectures of the far more banal cases that actually went to court, many of which are from that portion of the market that Kevin was describing. Kevin, so basically, you find architectures of McMansions, but also post offices, candle shops, interspersed in here, and again, some of this other material. But so for us, the question was, how do we conceptualize from an architectural point of view the fact that we can find multiple examples of projects orbiting around a similar architectural volume or formal concern? And we wondered if this was about influence and how one might describe what that means or define what that is. The colloquial understanding of influence involves a kind of intoxication, a lot like getting the flu, influenza being indeed the etymological root of the term. And when discussing influence in his famous 73 Anxiety of Influence, Harold Bloom invoked a kind of anxiety that plagues or directs every creative process. But perhaps more useful for my own polemic here, which hopefully works, is British art historian Michael Baxendale, who felt it necessary to correct the wrong-headed, this is now a quote from him, grammatical prejudice that comes with this term influence, about who is the agent and who the patient. It seemed to him that the concept of influence reverses the active-passive relation which the historical actor experiences and the inferential beholder will wish to take into account. If one is saying that X did something to Y rather than that Y did something to X, one says that X influenced Y, it does seem that one is saying that X did something to Y rather than that Y did something to X. And if Y doing something to X, meaning that the follower is actually doing something actively upon the work that they're looking at, if this is an appropriate way to describe much of cultural and architectural production, then we may need copyright laws that get at that process of creation better, or leave it alone.
All right. Thank you. Let's come back up. Now, I don't have my watch with me. It's 12:20. Oh, well, we'll do a quick conversation, yes? Can we go? So thank you, panelists, for agreeing to play with me. And in this context, I thought they were incredible presentations, and it's impossible to draw them together, but I think what I might do, I just want to introduce two moments in contemporary architecture, culture, and law to get at the question, which for me underlies all of these, as all of you were talking, despite the differences in subject matter and your expertise and the time period. For me, somehow this tension between architecture culture and its understanding and relationship to how we borrow and what originality means, that understanding versus legal protections, definitions of those ideas, that conflict between the legal and the architectural culture are really what interests me. And the potentially productive relationship, but one that also seems contested and complicated and hard to understand. Just as two examples I want to bring up, and both of these were extensively covered in the popular press within the last few years. And one was an architect, Zaha Hadid, who recently passed away, had designed a building for a series of these kind of, for lack of a better word, like pebbly-like kind of funky towers. Her work is always very amorphous, and it had come to light that there was a copy of these buildings that had been created in China. And for me, this brings up interesting questions, too, about the question of drawing versus building, because now that with a digital networked age, and when these images are available, I don't even know anymore how you distinguish the building from its representation on the internet in a way, right? I mean, there was no access to drawings. It was all just from images that they saw that they were able to construct this copy. Two interesting things. One is there was cultural differences where the Chinese, maybe like the Renaissance, felt like, well, of course, this is what, like, this is how we make things, right? So I think there's an important notion of cultural difference. Also, Zaha Hadid herself, the architect, responded by saying, well, then I guess I better work faster. I better do some more original work, right? It was this kind of idea like, I think that's this kind of driver of creativity through this notion of copying, right? The other case was a student who had been a student at Yale University who had been presenting a project in the context of a jury. I hadn't thought about this today, but in architecture, when you present your student work at the end of the semester, it's called a jury, and everyone evaluates your work, the jurors, other architects. And the student presenting his project, and on this jury happened to be a well-known architect named David Childs, who saw this project for this skyscraper that he did. Okay, a couple years later, David Childs happens to be the designer for the Freedom Tower in New York City. And then the student turns around and sues and says, you saw my project at Yale University and you're copying it for the Freedom Tower. Now, in this case, I think the architecture community thought, what on earth is this student doing, right? Culturally, it was completely bizarre. I love your comments on that. Just to frame the story a little bit. In the end, there was a summary judgment, as I understand it, that said there was actually nothing in the building that was original enough to warrant any kind of copyright. It was the kind of wavy. Okay, go ahead, Anna. She wants to jump in here.
With
yes?
this particular one, I think that is
Shine
actually,
versus Childs is the case. Yes.
Yeah, Childs versus Shine, or Shine Childs.
Yes. Yeah.
But in that particular case, Yale records the jury, so they have an actual voice recording of the architect salivating and getting excited over the project,
right.
And the geometry of the geometry of the two towers actually is not that far. I mean, the
yes.
geometry of the facade of the
right.
two towers is
right.
not that far.
Right.
So closer than some other things that have gone to court in a sense for a layperson looking at them just visually.
Yes. So I guess my broad question with just a few minutes is for the jurors to maybe talk about their experience with the panelists, excuse me, that was a slip, to talk about their experience with these discrepancies. And Jay, maybe you can lead us off, because I think you began by talking about that you had doubts about the usefulness of AWCPA, and we've talked about different examples now of how it might or might have not affected the way architects think or work, but as someone who's trained as an architect also and who knows these kind of two different fields, I'm just curious if you could talk broadly about what those doubts are, maybe.
Okay, sure, thank you. Actually, I'll sort of give two, and I think Kevin's comments made me sort of think about this a little bit more. I can look at this from two completely different perspectives. From the perspective of individual architects who are trying to maintain a business in a highly competitive industry with extremely narrow profit margins, and as I said, negotiating contracts with much larger entities who have much greater bargaining power, copyright law is a useful piece of leverage because if you can retain the copyright, then if you get in a fight with your client over whether you're being paid or not, the biggest piece of leverage you have is to withhold the ability to use your drawings until you get paid. So from that perspective, actually, for the individual architect, copyright law is a very useful piece of leverage. From the viewpoint of the larger culture of architecture, for the reasons that I think Cammy was describing, or I would broaden even further to the viewpoint of urbanism, most great cities are made of innumerable copies of a very few modules with relatively small but subtle variations. And in fact, more originality, I would argue, in individual buildings tends to produce worse urban environments. Originality is an enormously overstated value when it comes to making good cities. Dumb, ordinary buildings with kind of nice details and well thought out uses tend to make much better cities. So I have two entirely opposed viewpoints. From the viewpoint of individual architects, yeah, I'm going to use copyright to try to kind of protect their position in a very tough competitive economy. When I look out at cities and worry about, perhaps a chilling effect upon copying, I wonder, although I don't think it's really copyright, I think it has more to do with a prevailing culture of architecture and the way that we have actually overemphasized originality in the culture of architecture and architecture schools rather than copyright law per se.
So is one answer to that a kind of
Can
more
we have it
copyleft type of thinking?
Can we have it
Yeah, go
both
ahead.
ways, though?
What do you mean?
So I'm going to answer that we can.
Can what, have it both ways?
Yes, which I think we did have it both ways before the AWCPA, because when you're a custom architect, right, you want your drawings, right? You can't use the drawings. At that moment of negotiation and potential leverage of copyright, there is no built building to copy. That's the whole point, right? Is by the time you get to the owner-architect relationship where there's a built building to copy, you have a happily completed. And usually the architect and the owner doesn't want to build another identical copy, right? He wants the building that the architect was designing for him or her. So pre-AWCPA copyright granted architects the leverage that they need vis-a-vis clients by protecting drawings, but then strategically became weak at the moment when future generations or contemporaries might want to borrow from the buildings. So I'm on record saying there's hidden wisdom in pre-AWCPA copyright that most of the time when copyright or pre-AWCPA copyright is discussed in legal circles, it's viewed as this kind of weird, quirky thing. Why would you protect expression when it's in one material form but not the other? It's formalistic in a way that doesn't fit into what we expect of copyright law. But actually, I think it has a lot of pragmatic value precisely because it gives us a both-and solution.
But what about all the ways in which the work of architecture is defined in AWCPA? It's not just drawings or built form. The law seems to allow for definitions in many other media too, right? So certainly digital models are going to be included in that now. So how do you think that works in that sort of?
So prior to the AWCPA, so we don't have a lot of law about how pre-AWCPA copyright would have handled the digital model, right?
Yeah.
That's kind of asking for an anachronistic viewpoint. But one of the things, in addition to protecting built buildings, the Shine v. Childs case suggested that there was now protection for schematic models, which arguably, and it's ambiguous whether that protection would have existed under pre-AWCPA law because those cases weren't ever litigated, right? So And now it's true that there's uniform protection. I don't think the question is how did VAW-CPA copyright law protect them as a descriptive matter, because I don't think we have an answer, but there's a more normative question. Look, if we actually think there should be this divide, what kind of protection should be given to that? And my view is, look, there should be a lot of protection given until there's a full copy of the building built, and at that point, dynamics may change, and some rights anyway can be reduced.
But just one very quick addition. I think one thing that maybe needs to be amplified is that we've talked about kind of at the margins is the role of changing technology in all of this. And when I say technology, I also mean the invention of the printing press changed everything in terms of how ideas were distributed. Then photography changed everything in terms of how copies were. And now the internet has, both in terms of the detection of copies. So would Zaha Hadid ever have known that a copy, that a building or anyone had been built somewhere else? And then the access to information. So as a kind of future, I think one of the ability of the law to catch up appropriately to technology is, of course, a very broad issue, but I think it also absolutely applies to architecture.
Absolutely. I've been told that they are knocking down the doors waiting to come in for lunch. So I do hope that we will be able to continue this conversation during lunch. I hope that anyone who had a question and wasn't able to answer can give that to me or to the panelists at lunch. And I want to thank our panelists again and thank you all.
So